Hi everyone, welcome back to my YouTube channel. My name is Cyprianne Rookwood. I am a family law attorney, criminal defense and immigration law attorney in the New York City area, and I also handle cases in New Jersey. My office is based in Brooklyn, but I handle cases throughout New York City. If you're new to the channel, welcome. And if you are a returning subscriber, welcome back. Make sure you like, subscribe, and share. Okay, so today we're going to talk about custody and visitation. Although in New York, custody and visitation are two separate issues, if you are a parent seeking to establish some sort of visitation rights, it's advisable to file a custody and visitation petition. If you are seeking custody, again, it's also advisable. Usually the matters are kind of put together. The point is that if you file a custody and visitation petition together, if you fail on the custody part of it, you will very well likely to get some sort of order on visitation. So this is why it's important this is why lawyers, we usually do a visitation, a custody and visitation petition. So in New York, you can file for custody or visitation of a child up until they're 18. Even though child support, you can request child support up until 21. Visitation is up until 18, because obviously after a child reaches the age of majority, in most cases 18, the court can't really tell the child what to do, right? They can't really impose an order on the child if the child wants to stay with one parent versus another. So the court, or at least the court won't try to do that, because in New York, we do consider the rights and the wants and the needs of the child. And in many cases, the child is assigned an attorney to represent their interests. And in some cases, the attorney, do something representing the children based on the best interest of the children. But in New York, the attorney represents what the child actually wants and not necessarily the best interest of the child. Unless the child is really, really young and can't really articulate what they want, then in that case, the attorney will substitute judgment and do kind of advocate based on what is in the best interest of the child. But generally speaking, the attorney for the child, the AFC, represents the interest of the child and what the child wants. So in a custody and visitation matter, especially when it's very contentious, the mother has an attorney, the father has an attorney, and the children have attorneys. So sometimes it could be really hectic to have several different attorneys going at it, trying to resolve the case. So just be mindful of that. Even though you have all these attorneys going at it, ultimately the decision of the court is to determine what is in the best interests of the child. The court will take into consideration the arguments of the mother, the father, and the child, but ultimately it's going to evaluate what is in the best interests of the child. And there are factors to be considered, and statutory factors, but also the court has some discretion in that. And it's going to be based on case. It's a case-by-case basis. The interesting thing about family law is that even though we have the law, right, that's black and white, the facts, every family have different circumstances. And so family law is very fact-specific and outcome-specific based on those facts. And so that's the beautiful thing about family. I mean, the good and bad, right? The good and bad thing about family law is that you need an attorney who's going to be creative with, come up with creative ideas to advocate for you, and to come up with creative solution as well to get you the result that is best for you and that works best for your family. But again, it's really important to remember that the court is going to consider what is in the best interest of the child. That is the court's ultimate and paramount decision and paramount position, is to establish what is in the best interest of the child. And so the child's health and safety is the paramount factor in making that decision. And of course, the court considers other factors as well. But the child's safety, health and safety is at the forefront. It's the heaviest weight placed. The judge places heaviest weight on that. So the life that you live and the circumstances of your life and the environment that you live can have positive or negative effect on your ability to get a custody order. And it's also, all of that depends on how your attorney presented to the court, right? How much they place emphasis on certain things as opposed to staying away from other things. Because we all know that as parents, we all, or most of us, want what is best for our children. And so and who's best to know what is best for your children other than you, the parent, right? Who knows your children? The court doesn't really know your children. So it's going to be up to you to persuade the court to see things how you see it and to get the judge to rule in your favor. And that requires having an attorney who's going to listen to you and understand the circumstances of your life and understand how to advocate for you. One of the things that I try to do when it comes to family law is really listen to my client, because I think that it's very important to understand where they're coming from in order to effectively represent them. And so I really try to listen to what you have to say, to understand, even though sometimes you guys can go on and on about things that's not really relevant to the case, but in some extent it does help to understand you as a parent, to understand where you're coming from, to understand your desires, to understand how you parent, to understand why and how you make certain decisions. And that in itself helped me to be a better advocate, to represent your interests and to persuade the judge to see things from your point of view and to rule in your favor. So in New York, you can have, there's a distinction between legal custody and primary custody, right? So you can have joint legal custody of the child while one of the parent has primary custody. Essentially what this means is that as the parent of the child, you have equal legal rights to the care and upbringing of that child, to participate in the education of that child, to have a say in the religious upbringing of that child, to have a say in extracurricular activities sometimes. And especially a huge one is medical decisions, right? So having joint legal custody is important in regards to that. Physical custody, the parents can have joint physical custody, and it depends on the location of the parents, the residence of the parents. If they're in the general vicinity and it doesn't affect the attendance of the child going to school, etc., and it's in the same school district and stuff like that, or the same boundary, or not too far from each other, sometimes you can agree to have joint residential custody, sort of like on a rotation basis. It's not very popular because obviously a lot of times when people come to court, they're not seeing eye to eye and they don't agree. So that's I've rarely ever had a case where you have rotating custody, physical custody. But in a situation where the parents are on the same page and they can put aside their differences and agree, you can have that scenario. So you can have joint physical and legal custody. But in the event that you can agree and the child has to live majority of the time with someone, then you can have joint legal custody and then someone having physical custody. And then whoever does not have physical custody obviously have visitation rights to get to spend time with the child so that you can maintain a relationship and bond with the child. So just to go over some of the factors that the judge will look at. So one of the factors that the judge will look at is who has been the main caretaker or primary caretaker and nurturer of this child since the child's been born. So that's one thing, right? Also, the judge is going to look at the parenting skills of each parent, their strength, weaknesses, the ability to provide for the child's special need if the child has some sort of disability. So that is also taken into consideration. The court does look also at the mental health of the parent. Keep in mind, having a mental health problem does not automatically prevent you from winning a custody battle, but it is a factor that is considered. If you have some sort of mental health diagnosis and you're on your medication and taking care of yourself and doing what you're supposed to do, then obviously it's not going to really make much of a difference. But if you're not, then it can have a grave impact on your ability to get custody. The court is also going to look at your work schedules. Do you have time to nurture this child? Do you have time to raise this child? So the court is going to look at that. The court is going to also look at whether you have children in the home, if you have other children, and the relationship between those children and this subject child that's part of this custody battle. That's very important because the court wants to maintain its general policy, right? Public policy, that it's important to maintain sibling relationship. So that could also help you if you have other kids to kind of weigh in your favor, so to speak. But of course, the relationship between your child and your other children also plays a role. And also your relationship with your family as well, right? Especially if you live with your family, what kind of relationship do your children have or your child have with other members of your household? That's also a factor that the court considers. The court also, as I mentioned before, takes into consideration the maturity and the age of the child. The older the child is, the more weight what they want is good. The more weight the court is going to put on what they want, right? So that's why after 18, it's kind of like a no-go. Even though you're paying child support until 21, yeah, the court can't really impose child support, a custody order on a child over 18. So that's why it's like 18. But even with a 16 or a 17-year-old, even with a 13-year-old, actually, even in some cases, with maybe even a 10-year-old, depending on the maturity of the child, even with if the child is 5 and is articulate and mature. So even though in New York in particular, in other states, they have kind of like an age as to when the court puts weight on what the child wants. But in New York, the maturity of the child is what governs and not necessarily the age, because we know that some children develop faster than others and are more mature than others. So as long as the child is able to articulate what they want and it makes sense and the attorney can advocate for that, then the court is going to take that into consideration. Another major factor, and this is a big one, it's a big doozy. The court is also going to look at the relationship of the parents and the ability of one parent to encourage and facilitate the relationship between the other parent and the child. So if you are a parent that is, I don't know, I hate to use the word bitter or is a little bit resentful, and you try to interfere with the relationship of the child and the other parent, that could be used against you, right? Because we want to try to avoid alienating the child from the other parent, because we all try to believe, or we think, or we believe, it's the general consensus that it's important for children to have both parents in their lives, right? And so we want to present ourselves. I want to present my client's case as though they are, and this is also something I would get just from talking to my clients. So this is not something that I'm going to pretend on your behalf. If you're a bad parent, you're just a bad parent, and I'm going to tell you to get your shit together, right? But if you're a good parent, I'm going to tell you that it's better to try to be the reasonable parent. It's better to try to encourage and facilitate a relationship with the other parent, because that is going to work in your favor when you go to court. So with that being said, just remember, don't be the bitter parent. Think about the best interest of your child. Put your child's best interests first before your own personal feelings, because if you don't, it's not going to work in your favor. Okay, guys, so that's all I have on custody and visitation. If you have questions, feel free to comment in the comment section. Feel free to check out my website, www.rookwoodlaw.com. shoot me an email. If you want to request a consultation, feel free to also give my office a call, 718-879-3265, to schedule a consultation. If you're in New York City, I represent people in the 5 boroughs of New York City: Queens, Brooklyn, Bronx, Manhattan, and Staten Island. I also represent people in New Jersey. So feel free to give my office a call if you have questions, if you have kids and you want to petition the court. If you also, we handle modifications. So if you currently have an order, a visitation or custody order that you'd like to modify, I handle those as well. If you are doing relocation, I handle those as well. I will do a separate video on relocation in the coming weeks. So again, guys, please remember to like, share, subscribe, turn on your notification bell so you don't miss future videos. And thanks for watching. Take care until next time.